The following video is about a legal term that people may or may not have looked up. It will be in the title and description of this video. And below this video, as 2 comments, will be cut and pastes of someone's online work on drive.google.com/file/d/1r50bz- and a bunch of other characters. Warning, if you put up a text-only file as a PDF or a bunch of pictures, I'm going to convert it and post it publicly. You're welcome. Is this an authoritative source? Let's start with the central term that people are very deliberately altering. Knowingly and intentionally false statements, if they are necessary to the finding of a probable cause, and contained within an affidavit to grant a warrant, cause this warrant to be null. And so may be any evidence that was accessed through this not chain of custody, but chain of authority. Forbidden via reckless disregard for the truth at any stage. I'm going to give you an example that's completely fictitious. It's not exactly based on an actual case where this was brought up. But I want to point out that in 1978, a court case called Franks versus Delaware existed. And this is called a Franks hearing. Not a memorandum, not a memo, not file, not any other word, because the name Franks is the last name of somebody. And using anything other than Franks hearing means you're avoiding people being able to look that up. See also, stop posting your text-only evidence on websites by putting them in a format we can't cut and paste easily. Bitch. Now here we go. Who, what, when, where, knowingly or intentionally gave a false statement that became the basis for probable cause to request a warrant via affidavit citing said knowingly, intentionally false statement. And therefore, all evidence is thrown out. If you're not aware of it, this is a defense attorney method. If a defense attorney can prove in any way, shape, or form that any stage of an investigation, including someone intentionally, knowingly filing a false statement of any kind, anything that is produced from it, that would be reasonably produced from it, must be considered forbidden fruit. All right? The defense decides to dub a 12-page report with a word that would get search engine ranking and get people to super sleuth it, because truthers, sleuthers on the internet love buzzwords, love things that'll show up on search engines, and love Google trending things. This is attributed to, but not necessarily having anything to do with, the following names: Kevin Murphy, Greg Ferency, Todd Clicks, or Todd Click. I'm going to assume it's Todd Click because people keep typing it that way. And a connection to a place called Rushville. An affidavit, or info, or memo, or memorandum, which is what memo stands for. It was a Franks hearing. The defense challenged evidence collected on the basis of a warrant that was granted on the basis of false statement. See also Franks versus Delaware, 1978 case law. That's literally the 420 of it all. Yes, I made sure I timed it. So, what does this mean? Or is that 404 or 411? I think 420 works for everybody here. This is a Google Drive page I'm cutting and pasting from. You didn't put a copyright notice on it. You put some foul language in it. You have an explanation there, and I'm giving a link to the Google Drive page. I'm also going to bring up the fact that archiving any of this is a screaming cast iron pain in the ass, because you didn't put it in a format that's easily archived, meaning if you change your story, we can't tell. Did Todd Click, Greg Ferency, Kevin Murphy, and other names that get thrown in eventually have anything to do with an assertion that there were runes at the murder scene and it's the Odinists? Now, I want you to understand why I'm bringing this up. My client must be innocent because he's not a part of this subgroup called Odinists. What does that got to do with anything? Oh, well, a person says that their interpretation of imagery at the scene showed runes. These are pictures, right? Yes. Are the pictures posted? Now, if anybody's not aware of it, I did a video a long time ago where I tried to find someone who was honest about showing unedited, full-resolution pictures. And if you're not aware of it, at the time when people were making these assertions and trying to make it trend as a viral subject matter, because that helps the defense exonerate a potential murderer of children. What is this trend on the internet of everybody finding out that someone was a mass murderer or just a killer and trying to immediately exonerate them? I know it's Don Quixote-esque, but I understand, and I also understand a defense should go ahead and exhaust everything they can do. But why are you participating in it? Do you really believe that there's no possibility of ever finding the actual guilty party in anything? This is an aside, but I'm going to keep going with this. Years ago, a person who literally posted a video of himself murdering people tried to exonerate the guy, by saying he was never convicted because he died at the scene. He video recorded himself murdering people. He wanted to be known for it, but he has to be exonerated. Why in fuck would you take that tact? And why do people do it? Because you bring up subject matter that's in the news and take an opposing view to cause controversy so you can get hate clicks. People will click your video to downvote it. It's part of making money. Why is WAPTEC explaining this? Because some of you keep forgetting this. Now, do I believe there's an Odin report? The defense attorney has used that expression, Odin report, and used the word Odinist and other words. Also, we have something being called the Murphy report, or the Kevin report. It's Kevin Murphy. Why not use his full name? Because a Murphy report, while technically a reference, is not a trackable reference unless you work at it, which means you have to get up to your nostrils in this rabbit hole of assertions by a defense attorney that's being paid to get his client released and is not held into the standard that he has to tell the truth. Defense attorneys, by legal definition, are not required to take an oath to tell the truth. Neither are prosecutors. Oh, wait a minute, they are. You might have just heard what I said. Knowingly providing false information is only against the law and actionable to a prosecutor. Prosecutors have, in many cases, been jailed for withholding evidence. A defense attorney can, but it's really hard to do because if they're the only source. When you have a prosecutor prosecuting someone, there's usually an ass ton of people who have been part of the chain of evidence. When a defense attorney refuses to provide information, there may be only two people on the planet, and they have a motivated self-interest to not divulge the data. We find out years later, defense attorneys have been involved in cover-up after cover-up after cover-up. Are cops involved in cover-ups? Yeah. Do we have a fuck ton of corrupt cops and judges and shit? Yes. Do they do it for people who are guilty? Obviously. Are they directly connected? This is the assertion. Well, it's all the cops and Odinists and the cops because a patch or an expression was on a, quote, police officer's clothing. Now, I understand, yes, for legal purposes only, everybody working at a prison or jail is legally considered a law officer or peace officer and or technically flat out called a police officer. But they're not beat cops, and they don't pull you over. In fact, they're forbidden from doing these things because in court, you'll hear the words, he's not really a cop. But please contradict the living dog shit out of me because there's a technicality somewhere. Do you know the guy that pats you down at the airport is technically part of Border Patrol, etc., because they are technically. And did you know that it's a federal offense to literally yell at a mail delivery person? If a U.S. Postal Service worker is delivering your mail and you yell at them, that is a federal crime. Did you know that? Are they federal agents? Yes, there's a YouTuber who says that every single person who has protection through the federal government, just to keep harassment down to zero if possible, every one of them is an agent and they're following him because he's paranoid. But no, they're not federal agents. They're just mail delivery guys and gals. Okay? Your dog has more effect on them than the government. Okay? Okay, cool. So let's do our defense attorney assertion. There's a Rushville connection. We have 3 or 4 names that are brought up. We have a Franks not hearing, but every other word being used by people who are associated with a lawyer that knows it's called a Franks hearing. Okay, so about that, what is my assertion at this point? The only source I can find, and the only source a lot of you can find, isn't authenticatable documents. It's a bunch of memes. Now, I'm going to include one down below. It's a Google Drive file. It's the one I'm cutting and pasting. I don't know if it's factual. Pretty sure it isn't. I'm going to put up the comments and try to archive them. Now we're going to get to this part. Google, YouTube, and every other search engine, there is no good one, are censoring anything they want to based on flaggings. Yes, you can flag a Google result. You've been able to do that for years. The defense attorneys have a group that have been flagging any result that makes their client look bad. So the prosecution, right? Again, the prosecutors are held to a much higher standard because we have a presumption of innocence. And you can't prove it if you pay through PayPal, I guess. Next. If he's guilty and you kept defending him, are you going to keep doing it? Now I'm going to talk about the evidence. The evidence, the assertion. It's a false assertion. Why did they go to his house? What was the false assertion? Who made the false assertion? Somebody named Elvis is brought up. No, I'm not kidding. What was the exact statement? Where is your copy's defense of everything written down poorly and then typed up really poorly by Hunt and Peck by all the cops? Where is this documentation? Why isn't it the first fucking thing at the top of the page? Instead of, my client is innocent, hop, hop, hop. Between the 4 corners of this document. That's another expression I saw repeatedly. There's a lot of posturing and fancy talk, as some people would call it. hFRPd. I call it trying to sound authoritative to masses. Okay, now am I going to read through this? No. I'm going to cut and paste it for you to read below the video, below me, in the first 2 comments I post that I'm going to keep up there. And while it's unlisted but still visible, I'm going to try to archive them so that they're not erasable. And for the first couple of days, the comment will be left up, and then I will remove them so that you have the archive of them. In plain text, you can cut and paste and read to your best abilities. Warning, it's really poorly formatted. I had to clean up a lot of garbage from it, and strangely, the PDF version of it I found, again, this is the only one anybody even partially indicated, had hidden codes in it. So, enjoy the text version first, please. My conclusion about this. This is hearsay. The source of this, or not, is the defense attorney, or not. Give me the original documents to look at and a nice, neat file. Go ahead and make your own Google Doc with original files, with a link going back to where you got them from. If somebody doesn't do that at bare minimum, like you should do in a court case, I'm not analyzing it. Because there's nothing to analyze. Because you can't cite your sources? I'm sure there are sources, and I'm sure you'll have it. But everybody says this is a reconstructed version. Huh?